Good day, Crime Talk aficionados. It is Sunday, and we have the weekly recap from the week of November 4th with all the top stories conveniently located in one location. I hope you enjoy it. Have a wonderful day, and we'll see you next time on Crime Talk. And remember, the Constitution matters.
Hi, lawyer.
Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did.
Now, obviously, the crux of the prosecution's case in the Delphi murder is that the suspect, Richard Allen, confessed in custody. He confessed on the phone. He confessed to jailhouse personnel. He confessed to his psychologist. And now the defense is going back up and cleaning things up to show what he said was simply not true. And therefore, you can't trust the confession by Richard Allen. So day 15, ladies and gentlemen, day 15 of the Delphi murder trial. And for those who don't know, Richard Allen is charged with the murder of Libby German and Abigail Williams back in February of 2017. Those two young girls were found deceased near the Monon High Bridge there in Delphi, Indiana. Now, Allen was first investigated back in 2017 and then again in October of 2022. After a second police interview was conducted, after the FBI basically lost his first interview, they misfiled it, and therefore they didn't know about it for some 5 years. Crack government team on the case for sure. Anyway, the trial began on October 18th and was expected to go through mid-November. Originally, 16 Allen County residents were sat as a jury in this case, and one juror was dismissed on October 25th. Now, there are no cameras in the courtroom, and frankly, I'm not sure the prosecution want the cameras in there. Some of these things are a little embarrassing for sure. Just as to the level of the lack of investigation or the poor investigation. And I'm not sure the judge wants the people to see what's really taking place. Anyway, so what happened today? First, the jury came back in the afternoon, and the defense attorney called Jamie Jones. Now, this is Richard Allen's half-sister, and she tells the jury that she is 5 years older than Richard Allen, and obviously they lived together throughout their childhood. She says that Allen got married right after getting back from being in the military. And Miss Jones states that Allen did never touched her inappropriately or molested her in any way. And she was asked, would you lie for your brother? She says, no. Why is that significant, right? Some of the confessions were that he had done something inappropriate with his sister and even his own daughter, ladies and gentlemen. So the defense really has to show that this just simply is not true. Then the defense called Brittany Zapata, Zapanta. That's Richard Allen's daughter. Now, Allen is reportedly nodding his head as she takes the stand. And Miss Zapata tells the jury that she moved out in 2015 for a job, and she says she works in an urgent care facility. She attended Ball State University and then went to Indianapolis. Asked point blank, Miss Zapata, did your father molest you? No. Would you lie for him? No. The defendant finishes the direct examination of her. Rather short, rather sweet. That's the best thing about being in the defense. Get your witness up, you get him down, you ask a couple of questions before they can say anything wrong. All right? Anyway, Ms. Zapata was asked by the prosecution if Mr. Allen had changed her appearance in any way after she left for Ball State. She says no. He asked another question about Allen's height and weight. The defense objects from the prosecution question, and he shows Ms. Zapata photos of Allen. The prosecutor asks the attorneys asked to approach the bench. And after the sidebar, the prosecutor shows Zapata more photos and asks if certain photos look like her dad back in 2017. She said yes. The gallery did not get to see the photos. Now, the defense objects and says the photos are outside the scope of questioning, and there is another sidebar, and the judge sustains that objection. The defense also called a woman by the name of Shelby Hicks. Hicks says that she is a realtor. She was 23 years old back in 2017, and she tells the jury on February 13th of 2017 she took her car in for repair and went for a hike with her boyfriend. She says that they got to the trail about 2:30 p.m. and parked in a connector lot, and the defense attorney, Andrew Baldwin, is trying to get her to say the Mears entrance. Now, Baldwin asked her if there's anyone parked there other than her. She says there were other cars. Hicks says that they walked towards the highway for about 5 minutes and then went towards the bridge. She tells the jury it takes 10 to 15 minutes to get to the bridge, and she said she saw an older gentleman, 2 girls from school, and a few other kids. Hicks says that she saw an older gentleman with a camera and saw Cheyenne and Shelby Duncan from school, and she tells the jury she was there first on the bridge's platform. She said she did say hi to her friends from high school, and Ms. Hicks tells the jury that she was on the platform for between 15 to 20 minutes and went back to her car with her boyfriend. She tells the jury she did not remember if there were other cars there when she left. Now, Hicks says the next day her boyfriend Daniel wanted to tell law enforcement what they had seen, and she says they went to the police but were asked to come back at another time, and they went back that evening. Hicks tells the jury she did not hear anything on the bridge, and she says she met with law enforcement twice, first in February of 2017 and then again in March of 2017, and she says the police never took her phone to extract data. Then the prosecuting attorney begins a cross-examination, and Ms. Hicks says her cellular provider back in 2017 was Sprint, and she tells the jury she never walked across the Monon High Bridge. She does say that on that day she left the platform before her friends returned. Now, the jury had a couple of questions. The question was the man with the camera old? Hicks says yes. Did you arrive at the bridge at 2:55? Hicks said it could have been. At 2:29 p.m., the defense calls Steve Mullins. The defense shows Mullins a list of Ford Focus SEs in white, registered in Cass, Carroll, and Tippecanoe County between 2011 and 2017. Now, Baldwin says he only focused on the cars that were similar to Allen's, and the prosecutors object, saying it was not certified. Baldwin asked how many people owned similar hatchback models in Carroll County in the surrounding area in 2017, and Mr. Mullins says he didn't know. Baldwin says Mullins created a log of missing interviews. He said on March 18th that Mullins did not say that at the hearing in March. Baldwin raises his voice, then apologizes to the judge. Now, Mullins looks at the transcript from March hearing. He admits that at the time there was no log. He tells the jury there is a log in the filing cabinets from early on and says he's gone through the cabinets and found it since he testified in March. Baldwin then asks about Libby's phone. Prosecutor then asks for a sidebar. Baldwin says Dr. Walla was a fan of the Delphi sites and asks if it would be important to find out if a van was discussed on social media. Mullins said, I don't know, I didn't look. Baldwin says there was many mentions of a van on social media, and he says Mullins does not know what Wallace said when she was taking care of Mr. Allen. The jury asks the question, why would anyone discuss a van prior to Allen's confession? Mullins says that's why we looked into this, that this was the first we had heard of it. Baldwin asks Mullins if there was ever heard of a white van 30 minutes outside of Delphi with a suspicious thin man asking kids if they wanted candy. Mullins says he doesn't recall. The defense then called a gentleman by the name of Brad Weber. Baldwin asked him why he was upset when they talked before. Mr. Weber says, I was upset because you were trying to tell me what I did when I got off work. Baldwin handed him a transcript from an FBI interview Weber did in February 2017, and Weber tells the jury he went on a 3-day trip to Arizona and got back Sunday before the girls died. Baldwin asked him about his ATM machine business. Weber says that he makes money off of them through surcharges, and he knows how many he had in 2017. He says he has 30, and at one point he now only has 15. Weber tells the jury he attended to his ATM business machines daily, says he checks how much money they have and gets money from the bank. He says he doesn't know what bank he used in 2017. He thinks it was Regions Bank. Well, Weber says his ATMs are at a gas station, tavern, restaurant, etc. And he said that he used a black Subaru to drive to service his ATMs. And he says he uses Regions Bank now, but not always at the same branch. He says one day of the murders, he went straight home from his other job at a Subaru plant. Now, Mr. Weber tells the jury that nobody from law enforcement asked him to go to the police station this past August, that they asked him to go to a different location. And he says it could have been Steve Mullen that called saying, the only time I used my van was when I was pulling a trailer. Now, Weber says he took a nap when he got home and work on February 13th of 2017, got up about 5 p.m., and someone knocked on the door. Baldwin asked, do trespassers come onto your property? Weber says yes. Weber says, did he not hear any screaming that day? He said, had a home in Lafayette in 2017, and he owns a trailer. Now, Weber then tells the jury he gave law enforcement permission to go inside his house, but it was not on February 13th of 2017. He says his van was in the grass and the Subaru was in the driveway. Now, Baldwin hands him a photo of his garage from February 19th of 2017, and the prosecutor objects. The judge admits the photo over objection. The prosecutors then do a cross-examination of Mr. Weber, and Ms. Weber says that law enforcement stopped him on his way home a few times, probably in February of 2017, and he says someone looked through his property on February 13th, and he confirmed he talked to law enforcement on February 17th, and he went straight home from work on the February 13th. The jury then asked questions. Do you know if the ATMs would have photos or video servicing? Weber says not the actual ATMs, but some of the locations do. How far in advance would you have to order cash for ATMs? Weber says that getting cash isn't a problem, but a week in advance. What is the process to clock out of work? What driveway do you use at home? Driveways under the Monon High Bridge. Do you drive under the bridge? Would you have taken that route on February 13th? And Weber responded, yes. Do you typically go home before servicing your ATMs? He says no. So the jury then left the courtroom after that, and the defense said they had some more questions of Mr. Baldwin, saying that they have an offer of proof for a third-party suspects. He asks if Mr. Allen asked police if my spit was on one of those girls. The judge, Gull, then tells the defense, we've had this discussion 1,000 times. You have no evidence to tie these people to the crime. Well, they're clearly trying to tie Mr. Webster to the crime. Anyway, Baldwin says he has an offer of proof for the third suspect. He asks, once again, if Allen had asked police if my spit was on the girls. Judge Galls tells the defense, once again, we've had this discussion 1,000 times. There's nothing. There's no nexus. Move on. You're not getting your third-party suspects in this particular case. Now, there was also testimony regarding footage from inside Richard Allen's cell. The defense called an individual by the name of Max Baker to set up videos. He said the security camera video from inside Allen's cell does have timestamps, and the courtroom TV again was turned to face away from the gallery, only visible to the jury. Now, Baker told the jury he created the video by piecing together smaller parts of his cell footage, and video 1 was from April 12th of 2023 and included clips from a 5-hour time period. Video 2 was from May 25th over a 12-hour time period. It was noted that video 1 was an hour and 20 minutes long, and multiple jurors took notes while watching the video. An alternate juror, apparently who Russell said was a high school-aged daughter, raised his eyebrows throughout. Now, the prosecutors and defense attorneys were apparently gathering around to watch this footage. Video number 2 was 26 minutes long, and many jurors were watching, and they were looking at Allen as they were watching this video. The defense also called Dr. Polly Westcott. She is a neuropsychologist based in Carmel, and she told the court her specialty was in forensic psychology and neuropsychology. Baldwin and the defense attorney, Brad Rozzi, hired Westcott back in May of 2023 to assess Mr. Allen's emotional and physical health while it was declining when he was in the Westerville facility. Miss Westcott, Dr. Westcott, was given access to Allen's mental health treatment records, video footage from the prison, and access to his recorded calls. Now, she told the jury she received more information about Allen than she had in any other criminal case that she's worked before, and noted that Westcott stopped receiving videos from Allen back in March of 2024. She met with Allen in Westerville in August of 2023 and performed an assessment of him over a 2-day period. Spoke with his wife, Kathy, for additional information. Her report was 127 pages long. To jump to the assessment, Allen has a long history of mental health issues. Allen was not faking or exaggerating symptoms. Allen is slower to understand, process, and responds to things. Allen's experienced a complete mental health decrease in the Westville facility, and Allen has major depressive disorder and slipped into psychosis due to stress. Allen's brain chemistry was in fact changed while in prison due to no contact with family and friends. The attorneys showed Dr. Westcott Allen's writing samples she previously reviewed, including a letter he wrote asking for assistance from the court back in November of 2022, and a letter that he wrote to Kathy before incarceration. Prosecution objected to admitting the letters, calling them hearsay. Judge Gold requested a sidebar and later admitted the writing samples after redacting a few words. Dr. Westcott said the November 2022 sample was organized and well thought out, but the letter structure from a later sample was completely different and fragmented. And after reviewing the samples, Westcott continued discussing her evaluations of Richard Allen. She said she gave him an MCI, or mild cognitive impairment test, which is a comprehensive test for personality features and mental health disorders. The test also evaluated if Allen was faking his symptoms. The jurors had some questions for the good doctor. If Mr. Allen has the common sense to be afraid to leave his cell, would he have had common sense to fake his symptoms? Ms. Westcott said Allen's statements about being afraid was before his psychotic episode. Question, if he was depressed as a child, would that cause him to commit crime as an adult? Westcott said not always, and that it depends on the personality type. Would depression as a child cause them to become a sex addict? Ms. Westcott said no. And did you watch Allen's police interview from October of 2022? The doctor said she said yes. So, like I said, it was a busy day in court. That is a quick recap of it. A lot of stuff going on. It'd be a lot easier if we could just all watch the video.
Next, Lori Vallow gets some new attorneys, and they say, whoa, let's withdraw that motion regarding competency. That's right. Now, Lori Vallow is accused of conspiring in the fatal shooting of her fourth husband, Charles Vallow, and plotting the attempted murder of her ex-niece's husband, Brandon Boudreaux. Now, in the case of Charles Vallow's murder, Lori's late brother, Alex Cox, actually claimed that it was self-defense, and police in Gilbert, Arizona, believed Cox was the shooter in the Boudreaux case. Now, Cox died back in December of 2019, and initially the trial was scheduled for August 1st, but a judge later decided to push the trial to February 24th of 2025. Now, despite Vallow not waiving her right to a speedy trial, the trial has since been put on hold. Anyway, so Vallow was extradited, if you don't recall, back to Arizona in November of 2023 after being sentenced in Idaho to life in prison without the possibility of parole for killing her two youngest children, Joshua J.J. Vallow and Tylee Ryan, and conspiring in the murder of Tammy Daybell. Tammy was the former wife of Chad Daybell, husband number 5. So a little over a week after a judge granted a motion for competency and request for new lawyers for Lori Vallow are asking to withdraw the request to undergo a mental competency evaluations. Now, lawyers for Lori Vallow have filed a motion to withdraw that Rule 11 request. They want more time to review 5 boxes of records as well as a hard drive with 16 terabytes worth of data that they need to decide on what information actually goes to the doctor. Just for frame of reference, I thought this was rather interesting. 1 terabyte is about the equivalent of 250 movies or 6.5 million documents. I'm going to have to remember that little fact when I request a continuance, because now we get cases that have literally 7, 8, 9, 10 terabytes of information. It's amazing the amount of information the police can collect these days. Anyway, in addition, the new attorneys also say they need time to have a meaningful opportunity to speak with Lori Vallow, and that she requests an expedited in-person hearing. Now, Vallow's former defense lawyers filed a motion for the Rule 11 evaluation, the competency evaluation, and they're asking that she be declared incompetent to stand trial in this particular case, just like what took place in Idaho. As you may recall, the attorneys had her comped in Idaho, and it took 10 months for the state of Idaho to restore her back to competency. Like I've said in the past, is she crazy, like mentally not competent to proceed, or is she crazy like a fox? Is she playing everybody? We'll have to wait and see.
Next on the docket, guess what? Sarah Boone, big shock, wants a new trial. Now, obviously, Sarah Boone is awaiting sentencing for her murder conviction, and her attorney is trying to get a new trial by arguing that the judge erred in his rulings and that there was prosecutorial misconduct. Now, a jury convicted Miss Boone of second-degree murder for the death of her boyfriend, Jorge Torres, who was found zipped up in a suitcase in the couple's apartment after a night of drinking. Now, Ms. Boone testified at her trial that she had acted in self-defense and that she suffers from the battered spouse syndrome, while prosecutors emphasized that she left the victim to suffocate after additionally beating the suitcase with a baseball bat. Now, at trial, Ms. Boone was represented by James Owen. Now, while Torres died back in February of 2020, Boone's case didn't go to trial for 4 years, in part due to delays caused by a constantly changing defense team by Ms. Boone. 8 attorneys represented Ms. Boone before Judge Michael Kranick ruled that she had forfeited her right to an attorney and she was going to represent herself. Now, in the motion for a new trial, Ms. Boone's attorney, Mr. Owens, argued that the rulings violated Ms. Boone's Sixth Amendment right to representations. Owens also said that Ms. Boone's behavior did not rise to the level of misconduct requiring to sustain the ruling that the judge failed to warn her that repeated misbehavior would result in her right to have to represent herself. Yeah, that's not going anywhere. Let's be clear, ladies and gentlemen. Oftentimes, you can file a motion for a new trial prior to sentencing. It's going to be denied. Okay? I honestly don't think, one, I've maybe done it twice in my 30 years of practice of law, and I can't say that I've ever seen a criminal court judge reverse themselves. District court judges don't reverse themselves. That's what appellate courts are for. They're not going to say, I made a mistake. They're going to say, I'm going to double down on my decision and we'll let the Court of Appeals decide if they did it wrong. In this particular case, Ms. Boone made a clear record that her misconduct, her inability to get along with court-appointed counsel was that she couldn't get along with anybody and therefore she could in fact represent herself. Ultimately, this other attorney stepped in, Mr. Owens stepped in, basically doing the case pro bono, and he knew what the deadlines were. If he didn't think that he had sufficient time in which to prepare to effectively represent her, he should not have got on the case. And then Ms. Boone would have had a much better argument that she was deprived of her right to counsel by having to go to court with no attorney. But she had one who was aware of the deadlines and frankly did a decent job. And there you go. We'll have to wait and see.
Next, the Bryan Kohberger matter. Yep, some of their arguments were falling pretty flat in front of the judge. So Bryan Kohberger, obviously accused of quadruple murder, received a little bit of a, warning from the judge that was newly assigned to his case as he tried to eliminate the threat that he could face the death penalty if he's ultimately convicted. Now, for those who may not have been following this case, Bryan Kohberger is accused of brutally murdering Ethan Chapin, Zaina Kernodle, Madison Mogan, and Kaylee Gonsalves in their off-campus house in November of 22 there in Moscow, Idaho. Now, in court on Thursday, his legal team has a lengthy list of reasons they think why the death penalty should be taken off the table in this particular case. Now, in the conclusion of the final last-ditch argument, which stated that the death penalty does not reflect the international law and modern-day standards of decency, Judge Stephen Hippler gave a pretty straightforward response. I understand that argument, he said. It's falling as flat as you would expect it to fall. Well, the judge has spent 4 hours listening to a host of reasons the defense opposed the death penalty in this case. While he was officially taken all of the motions under advisement, he questioned and pushed back on many of the claims that were made by the Kohberger defense team. Now, ladies and gentlemen, Kohberger's attorneys are doing what they're supposed to do. This is death penalty litigation. You're attacking the constitutionality of the death penalty, the changing standards, cruel and unusual punishment. That's what you do. All right? That's what you do. Are any of these motions going to be granted? No. They were making their record. The judge allowed them to make their record. They will all be denied. The death penalty is not cruel and unusual punishment under the United States or Idaho Constitution. A death penalty defendant gets super duper due process. more than anybody else would ever get because it is a death penalty case, right? And remember, the Fifth Amendment of the United States Constitution says the government shall not take your life, liberty, or property without due process. Clearly, the founding fathers, when they drafted the Constitution, understood that they could take your life, your freedom, your liberty, and your property, and you have to be paid just compensation for it. Why? That was a big thing that they had a problem with the king, right? He'd go and kill somebody and wouldn't give them their day in court. It's not going away. States can ban it if they choose to do so. It's still there on the federal level, which is not applicable in the Bryan Kohberger matter. But the fact that it has never been repealed shows, other than that very short time back in the early 70s, when the Supreme Court said it was cruel and unusual punishment, and then they reversed and said, no, it's not cruel and unusual punishment. I get what they're doing for Bryan Kohberger. They're being his lawyer. They're being excellent attorneys for Mr. Kohberger. But these motions are all going to be denied. And then ultimately a jury will decide whether, one, Bryan Kohberger is innocent or not guilty, and whether the prosecution proves their burden of proof beyond a reasonable doubt. Ultimately, a jury will decide whether Mr. Kohberger is worthy of the death penalty. That's for them to decide. Now, we'll give him the presumption of innocence because that is what he is entitled to. His attorneys are doing a good job, but to use the word of the judge, your argument's falling as flat as you can expect it to be. Next, let's talk about the Daniel Penny matter. That's right. The Marine Corps veteran Daniel Penny is on trial for manslaughter in New York City after placing a homeless man by the name of Jordan Neely in a deadly chokehold on the subway back in May of 2023. Now, a 911 call played for jurors Thursday captured a teen passenger saying the troubled Mr. Neely was trying to attack everybody before Mr. Penny put him into this chokehold. Another witness testified earlier in the week that she was also nervous and that Neely ranted, raved, and threatened strap hangers that she thought she was going to pass out. Now, witness Lori Citro said even though she had seen many troubled people during her 30 years riding the New York City subway, Mr. Neely's rant felt different and scary enough for her to barricade her 5-year-old son. She said, quote, "No, I did not feel safe when he was moving around erratically. I've taken the subway for 30 years and I've seen a lot. I've seen a lot of unstable people. This circumstance felt different to me." She said, "I felt concerned enough to put a barrier in front of my son," the mother noted, adding that her fear was that Neely was next level. She said Neely was coming within a foot or less of people's face on the F train subway car, and he was riding, and it made everybody scared what he might do. And when Mr. Daniel Penny, the Marine veteran, intervened, she was relieved. She said it didn't seem like Neely was resisting much against Penny, who put the homeless man in this chokehold, and it didn't seem like Neely's breathing was in any type of distress. Now, the mother described to jurors being so scared of this belligerent, unhinged man, like I said, that she felt scared and was protecting her child. Now, Lori Citro is a research director and mother of two, had been in the train with her young son to a therapy appointment when she noticed the commotion and all the shouting that was caused by Mr. Neely. Apparently, he was shouting, "I don't have water, I don't have food, I don't have a home, I want to go to Rikers, I want to go to prison." Neely started lunging in different people's directions, Ms. Citro testified, and later demonstrated to the jurors the movement that Mr. Neely was making. He was erratic and unpredictable. She was scared, she recalled, and it was increasingly loud, and it felt increasingly threatening. And she would describe it as belligerent and unhinged. I actually took the stroller that she had and put it in front of her son, she noted several times. Now, once Penny intervened to stop Mr. Neely, Citro said, "I felt relieved because I was scared for my son." Now, Mr. Penny's lawyers have said that he shouldn't be held criminally liable for Neely's death since he was simply acting to protect himself and others' riders. Ladies and gentlemen, that witness right there, the prosecution's known about this witness. This is the prosecution witness, and yet here we go. Why is Daniel Penny being charged in any way whatsoever? He did not kill that man. He did not kill Mr. Neely. This is why Alvin Bragg is the biggest garbage prosecutor in the country. Now, yes, there are a couple that are close behind, but Alvin Bragg is probably one of the worst district attorneys here. They've turned this into a race issue, and it's simply not that. The district attorney should be embarrassed. I hope the jury finds Mr. Penny not guilty.